Honourable Marianne Street.
I rise to speak to this third part. Mr. Chairman, I recognise that I don't have the legal training that the Minister sponsoring this legislation has.
Point of order, Honourable Steve. Right.
Even here from here.
Yeah, we're away.
Thank you.
Could you make a comment to me?
Start again. 1, 2, 3. Testing. Hear me, Mr. Chair.
Would you like to move to another mic? Can you do that? Move to your right. Or try again.
Have you got it right yet? Is that better?
No.
All right.
Yeah, it's going now.
Is that going?
Well, no, it's not.
Well, shall we try this one? That's better. Okay. I've never had trouble being heard, and I presume my speaking time starts now, Mr. Chairman. Thank you. Thank you very much. I was saying, Mr. Chair, that I don't have the legal training that the Minister sponsoring this legislation has, and so I confess readily, being a humble arts graduate, that I need to go back to principles that simply make sense to me. And so I find Part 3 of this legislation quite challenging. And I think that's because it is genuinely difficult. I don't think I'm as illiterate as other members might class me as being, but it seems to me that if we go back to what this legislation is about, we get to the heart of it in Part 3. We have in Subpart 1 the participation in conservation processes in common marine and coastal area. In Subpart 2, protected customary rights. And in Subpart 3, the idea of customary marine title. Mr. Chairman, if I go back to basics and I say, right from the start of the debate on this part, that Labor's basic position has been to guarantee public access, number one, to recognise Māori customary rights, number two, and to allow Māori to take all aspects of their claims to the court. Those three things are simple principles that I can understand and I can describe to other people. And that's always the test for me. Can I describe what the legislation means to other people? And so I've worked quite hard at this, and I want to go in at the bit that is perhaps the most contentious, and that is around customary marine title in Subpart 3. Because some of the earlier subparts of this section of the legislation are reasonably okay. So, for example, there is now widespread agreement that rights of free public access to the foreshore and seabed and so on are not at legal risk, and that the alienation of customary interest, preventing that alienation of customary interest is widely supported. And so I won't traverse those things so much, but when we get to this bit about Subpart 3, then suddenly I begin to get suspicious. Because what we have here is the meaning of customary marine title and this attempt at codification of it, to which the Minister referred in his opening remarks. My experience of codification in past lives has been that it is an extremely complex and a difficult and exhausting process, because the codification of a right often requires a level of detail that is needed to address every issue that one can reasonably expect to arise where a right might be applied or sought to be applied. And so codification, I think, is a very complicated process. But the thing that puzzles me most about this effort in subpart 3 is that our position is that we are happy to lay out general principles and have the court determine on application how those principles might be applied in determining whether or not customary marine title exists. The two things in clause 60 of subpart 3 that are important here say that customary marine title exists in a particular part of the common marine and coastal area if the applicant group A holds the specified area in accordance with tikanga, Mr. Chairman.
Marianne Street.
Thank you, Mr. Chair. And B, has exclusively used and occupied the specified area from 1840 to the present day without substantial interruption. And that is problematic for many iwi. It is extremely difficult for iwi to prove, and it's extremely difficult for iwi. Well, the ones I've talked to who are represented by the iwi leadership group, which is most of them, say that this threshold is unfair. Now, the issue here is that the Māori Party was founded on the basis of what they considered to be a flawed piece of legislation passed by our government in the white heat of the racist opposition that the National Party had been drumming up over a number of years. And Don Brash owns his part in
order.
that.
I think I know what the point of order is, and I've just been reflecting on the way in which the member used a certain word. And the test really is the House itself offended on a word like this, and the context in which the member used it was. I know she didn't personalise it, but it does bring offence to the House, and I'll just ask the member to desist.
Thank you, Mr. Chairman. I will desist. In the white heat that the National Party generated at the time of the passage of our legislation, the Māori Party said that we were taking away the right to go to court. And we have said since then, and I said yesterday in this very debate, that was something we got wrong, and we have apologised for that. Now, this codification part of the legislation is trying to do much the same thing. The concerns that we have in the Labour Party, and I go back to simple principles, is that this appears opaque. It is not transparent. I would rather provide guidelines and principles in legislation in this House and have the courts, people whom the Minister and the Chair trained with in her previous occupation, have them, those who are now judges, have a look at this and see how to apply it. And let's build up some case law and some practice around this. Mr. Chairman, that independence of the judiciary is something that is extremely important to our democracy. And I, for the life of me, cannot understand why the Māori Party finds this bill fit to support when it continues the denial of access to the courts that provoked the establishment of that party. And so, Mr. Chair, this is a real puzzle to me, that the Māori Party, on whose votes this legislation depends, are violently opposed to a restriction of access to the courts in 2004, yet come 2011, when this Parliament is having a second go at addressing this issue in the interests of all New Zealanders, they think it is now okay to have something codified in legislation and not able to be taken to the courts for testing. So, Mr. Chairman, I think this is an enduring conundrum in this legislation.